to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we look at driving while suspended. Now, in New Jersey and most states, I'd say there's a requirement. The driver's license just can't automatically be suspended without any notice to someone. But all that's required is a notice being sent by motor vehicles to whatever address the person provided. So it's important that someone, I'd say, keep their address up to date with motor vehicles. Occasionally people are stopped and police say, okay, your license is suspended. People says, why? Police looking at the computer goes, I don't know. So it's a good idea if someone calls Motor Vehicle Commission right away. It used to be called DMV. Find out, okay, why am I suspended and what do I have to do to get restored? With the ticket, you want to sit down with the attorney, see what kind of defenses there are to the charge. Because sometimes the person, there's not really any defense, it's just really whether or not you can work out some type of plea deal with the prosecutor. On a first offense, driving while suspended, it's a fine of $500, $750 in surcharge, 9 points, and driver's license suspension up to 6 months. Second offense, $750 fine, $750 surcharges, 9 insurance points, and jail of 1 to 5 days, mandatory jail, and license suspension up to 6 months. So sometimes we can convince the judge that they should be given credit for the date that they were stopped as an arrestee. Third offense, mandatory 10 days in jail, $1,000 fine, and all those other suspension surcharges. If someone's suspended for DWI, then there's additional mandatory jail time. So it's important to get a good attorney. The attorney will file a request for discovery with the prosecutor, requesting proof of mailings if the suspension was by the Motor Vehicle Commission, both the notice of suspension and the order of suspension. If it was a court-imposed suspension, was it a suspension where the person was in court or they weren't in court, such as failure to pay fines or a parking ticket? If there's a question as to why the person was pulled over, the attorney can file what's called a suppression motion. And lastly, when going to court, the prosecutor in many cases can engage in a plea bargain. But the important thing is to keep your license up to date and make sure motor vehicle knows where you're at, because you can't, it is not a defense that someone says, well, I moved and I didn't get the notice. That's not a defense recognized in New Jersey. For other information on defenses and help with driving while suspended tickets, visit website njlaws.com or website benotguilty.com. That's benotguilty.com. And for representation, call the Law Office of Kenneth Vercammen, 732-572-0500. Thank you and good luck.
Action.
Hello and welcome to the Kenneth Vercammen Law Office Legal Podcast. In this edition, we explain powers of attorney. Now, many people have wills, and you don't need to be rich or near death to have a will. It's important to have a will because the will sets forth if you pass away, who's going to be your executor, that bills be paid, and how your assets are distributed. But not enough people do any sort of proper planning for becoming disabled. Now, similar to dying, people don't plan on becoming disabled, but people get in accidents, they fall down steps, they break arms, they break legs, and they're temporarily disabled. So it's a good idea for people who have a house or have kids to have a power of attorney. With a power of attorney, you are giving someone the power to make sure that your bills are paid, that all your accounts are handled properly. And for most married people, they make their spouses for the power of attorney. And then another family member. If someone doesn't have a close family member, they can pick an attorney that they trust or accountant that they trust. Now, there's two types of power of attorney. One is power of attorney that's effective right away. That's called a durable power of attorney. Other powers of attorney are only effective if someone becomes disabled. That's called a springing power of attorney, because that becomes effective. It springs into effect when someone becomes disabled. But it's also important to do these while summoned as well, because my office often gets calls by someone saying, listen, I need to get power of attorney from my mom or from my uncle. Okay, well, when can they come in? Versus, well, they can't, they had a heart attack or stroke. I guess, well, are they competent now? Because we can't prepare a document for someone else. We have to prepare it for the person who is ill, and we really need to talk to them first and make sure that's what they want, not that some relative is just trying to get control over their finances. If they wait too long and the person is not competent, then the family has to go through this very expensive, embarrassing procedure called the guardianship, where you're asking a court to declare someone incapacitated and basically incompetent, which used to be the old standard. So these powers of attorney, you meet with your attorney, you indicate who you want as executor 1, executor 2, prepare the documents, and they're signed. The cost is under $200, and that's a big bargain considering that the cost for doing a guardianship could be over $4 grand. For other information on powers of attorney, visit website njlaws.com or website Central Jersey Elder Law. You can also, for representation and preparation of documents, contact the laws of Kenneth Vercammen at 732-572-0500. Thank you and good luck.
Action.
Hello and welcome to the Kenneth Vercammen Law of His Legal podcast. We're looking this week at living wills, and people also refer to them as advance directives for medical care. Think of the Karen Ann Quinlan case and Terry Chavo case where the person's in a coma, irreversible condition, and the question is, well, what did the person want? Should life support be continued? So in New Jersey and most states, the legislatures have recognized people have a right to, in writing, advise doctors and hospitals ahead of time what their wishes are. So a living will is where you're giving these types of instructions. Now, in the living will, the first section that we have typically deals with if someone's in a coma, irreversible condition, they can't talk anymore, whether or not they would want fluids and nutrition to be provided or fluids and nutrition to be withheld. We're not talking about euthanasia. We're not talking about don't resuscitate. It's really should fluids and nutrition be provided. The next section deals with artificial means, and most people are of the, I don't want artificial means, I don't want artificial machines, if there's no hope for me to come back and live, really be happy and conscious, I don't want artificial means done. In the power of attorney, you're usually picking someone that that the doctors can talk to in order to make any decisions that the doctors think may be appropriate. There's usually a first person, second person. We usually don't like to have joint people because if there's two people and they don't agree, then the only person that can decide that is a Superior Court judge. Attorneys do powers of attorney. They're signed in the law office, and that's good. If someone is ill, attorneys oftentimes will go to the hospital, but we usually need something in writing from the doctor saying at least they're competent to do that document and want to talk to the people ahead of time. For preparation of powers of attorney, contact the law office of Kenneth Vercammen at 732-572-0500. There's other information on powers of attorney on website njlaws.com. Thank you and good luck.